Hello everyone, my name is KENNETH VERCAMMEN and I'm an attorney in Edison, and I'm here to talk for I think it's 35-40 minutes on wills, power of attorney, living will, etc. But as we go, if anyone has any questions on that topic, please raise your hand. Let me know what the question is. It has to pertain to New Jersey, and it can't be a story. Sometimes with the seniors, I have a question, and it's a long story about a friend whose case was in, Florida or New York. So let's start with taxes. Believe it or not, New Jersey has reduced some of the taxes. So New Jersey eliminated the New Jersey estate tax. For New Jersey inheritance tax, there's no tax that is going to spouse, children, or grandchildren. There is a federal estate tax, but it only applies to the people in the two back rows that have more than $15 million. All those other people in the front, don't have to worry about that. People also ask us, hey, to hold it, why do I need to have a will done? Doesn't automatically go to my spouse and my kids. Well, sometimes yes or no. If someone has a spouse but children from a prior relationship, then that child from a prior relationship gets a piece of the pie unless there's a valid will. Also, something interesting has since come up on, if there's these children from the other relationship. Let's see, one of our clients said, "You didn't list my children's names in the will." And I told the lady, I goes, no, because most women kind of know who their children are. I never had a baby, but they say it's not a fun thing. Today was the Boston Marathon, and I remember running for 26 miles in the pouring rain when it was 38 degrees, where someone said, "Oh, perfect marathon weather." But they say compared to having a baby, that's easy. However, let's see, for the guys, okay, there's a new thing called DNA and Me and Ancestry.com, and all of a sudden these guys are getting like letters or emails from someone saying, "Hey, the internet says I'm your kid. We did DNA testing," and the guy goes, "Okay." Apparently that was the weekend down in Belmar that I met some girl. I forgot her name, but I guess I got a kid. So that's a kind of a new reason why some of the guys should have wills saying, "Listen, I don't want this unknown person to be able to go before a judge and say, I get half of the pie. I want it to the people I care about the most." And also, interestingly, you don't have to. Who do you have to give your stuff to? The answer is whoever you want. The only thing you can't do is leave a spouse penniless. But if someone wants to leave all their money to the Yellow Dog Society, they go the retrievers and the Yellow Labs get it. Let's see. If someone doesn't have a will, let's say there's 3 kids, no dispute, no spouse, the process becomes more complicated, because that means that all the kids got to agree upon who's going to be the administrator of the estate when there's no will, and the ones who aren't going to be administrator have to sign a renunciation in front of a notary and have to pay a fee and have a file with the servant. And that's where everyone agrees. If everyone doesn't agree, then whoever wants to be the administrator has to spend thousands of dollars having a complaint order show cause, and has to be decided in front of the Superior Court judge. So the idea is, by doing good planning, you're making things easy for the people you care about, and you're also protecting them from the ones that you don't care about as much. Also, if there's not a valid signed will, then the administrator has to take out an insurance policy called the surety bond for $1,000 or $2,000, and they don't get that money back. Number kind of number 3 is if there's no close relatives, the state of New Jersey gets your money. And how many people have ever said, you know what, they need the money more than me, I'm not going to do it. No, because I want them to get nothing. Let's see, yeah, you know, so the bottom, and also the most important thing is when someone doesn't have proper planning, then there's often fights, arguments, sometimes lawsuits amongst family. The surrogates are all unanimous saying, go get your will done and get it done right, and don't use forms online, because the surrogate says the majority of times we had to reject the will for probates because it wasn't done right, it wasn't signed right, and someone goes, well, this is what it said on the website, and the surrogate goes, well, okay, go get your $12 back, but you know, it wasn't signed properly. So think about it. Who do you want to get your assets, and who you don't want to get your assets? It's as simple, it's really as simple as that. So let's talk about the difficulty of getting a will done. It's not difficult at all. We've never had anyone after doing a will say, oh, that was so complicated, or I wish I didn't do that. You know, because we learned a couple of things when we got closed down for COVID. People could come into offices, so I goes, you know what, I'll email you the questionnaire. And almost like 95% of people said, well, this is easier. This way I can just type in while I'm at home, you know, who's going to be Executor 1, who's Executor 2, and who gets my stuff. And it became easier in a way for us because the old system of people writing stuff down, I couldn't read their handwriting. And especially where I'm at in Edison, the husband and wives had different last names, and the person who they had as their executor, a family member of the, had a different last name. So I go, well, they typed it up, and that's all typically we need. Also, I mentioned New Jersey did away with the estate tax. So our form from 7 years ago was 7 pages long, asking lots of questions on assets. Now I tell everyone, I don't need to know your assets. You know, a gentleman goes, oh, I'm trying to get together. It's taking me a lot of time, my list of what my assets and my account numbers. He goes, why do you need that? I don't want to know that. That's your personal stuff because you're emailing it to me. I just need to know what real estate you have in New Jersey and what real estate you might have in any other state. Let's see, and for some of the people, like you know, we said we'll email the questionnaire, and you know, some of the ARP people, my Elks Club members, Legion friends. Oh, I'm not going to computer. I goes, well, that's okay. You have a family member who's good. You got a kid or a grandkid. And one of the ladies I was talking to, and I go, where does your granddaughter live, and how old is she? He goes, she's 17, and she lives like 2 towns over. He goes, okay, you tell that granddaughter that you're going to give her $5,000 to come and visit you in the next 2 weeks, and she's going to help you. She's going to help you type up the little form. And if that granddaughter says, Grandma, I'm too busy for the next 3 weeks to visit you, he goes, okay, no problem, because I was going to leave you money, but now I'm not going to leave you anything because you're not willing to help me out. You're not saying to the granddaughter, listen, I need you to come over to my house and clean my toilets, and it goes, just help me because you're better at that than me. Okay. Executor. There should be an Executor 1 and Executor 2. You don't want to have joint executors because joint executors mean two people gotta sign every check and do everything together. You want a number 1 or number 2. Now, let's see. Let's put people on the spot. Who in this room already has a will done? Come on, raise your hand. Good, okay. So, you also want, now, the people who already have a will, you want to look to see, hey, the person who I have as Executor 1 and Executor 2, can they still do the job? Our kind of rule of thumb is, can they drive to a bank and can they walk up a flight of steps? If they can't, maybe there's someone else better that can do it. You know, because you know, yeah, we're not anti you know, retire. We got to be practical. That if someone can't do the work, then we want to do it while we can. Okay. So who in your will? Yeah.
I have a question.
You have a question, Miss.
Okay.
Oh, by the way, she asked the first question. So, Dan, could you please give that nice lady the law points for senior citizens, even though she's not a senior citizen?
Oh, thank you.
Senior citizens are people over 85 now, by the way.
Okay.
Except when he can get the free Social Security, and then he goes, okay, that's either 66 or 60. Tell me what your question is.
Okay, so the executor, 1 and 2.
Yeah.
Okay, so he would be my first executor, let's say, and another executor, number 2. All right, suppose he passes. I'm sorry. Yeah, suppose he passes. I didn't change it. Would go to the second executor. Suppose they won't do it, and then what would happen?
Well, okay, so if executor number 2 won't do it, then it's up to the beneficiaries to say, hey, listen, I want you to, Judge, I want you to appoint me as what's called the administrative CTA of the will, and I want to be the person who I want to do it.
So somebody, one of the beneficiaries?
Well, it's typically one of the beneficiaries, because who else wants to do it?
Yeah. Okay, all right.
Yeah. So, did I answer that question?
Yes.
Perfect. Okay. So, in your will, you're listing who gets your stuff. And like traditionally, it was everything to spouse, then to children equal shares. And if there's no, if one of those children's pass, it will go to their grandchildren, or their children who's your grandchildren. And if they don't have anyone, it goes to anyone else. But remember, it's your right to leave your assets to whoever you want. More and more people that have children and grandchildren say, you know what, my children are already grown. I'm giving it to my grandchildren. They need it more than my own kids. My own kids would spend it on cruises, and they haven't put away any money for their own, really for their kids. Some people, older people, goes, I'm giving it to my grandkids. I won't be around when they need it, but it's kind of my legacy to them. Let's see. I remember I went to this college, University of Scranton. I love Scranton. One year, I think our kids were in grammar school, and I said to my wife, listen, I'd like to give Scranton $4,000 this year. My wife goes, $4,000. How much have you put away for your own kids this year? Nothing. You're going to give total strangers $4,000, and you haven't put away any money for your own kids. Well, since you put it that way, I guess Scranton's not going to get $4,000 this year. So you always want to have in your will, if one of the beneficiaries is gone, who gets that person's share? Don't leave it dangling. Okay. Also, sometimes people have what's called specific bequests. What a specific bequest is where you're specifically giving money or items to someone. So sometimes the ladies will say, listen, I want my jewelry to go to my daughter, my granddaughter, because if my son's the executor, he's going to go bring it to Cash for Gold on Route 18 and goes, what do you give me for this junk? Grandma's right, what is this junk? Okay? Some of the men say, listen, I got these, this Joe DiMaggio autograph, and I got it from my father, and I wanted to go to another guy in the family because I know my daughter, the executor, is saying, I'm getting rid. None of this junk is worth anything. I'm putting it by the curb. Some people say, listen, I'm active in my church and my charity. I want to leave them some money. Now, I'm all in favor of supporting charities and churches and whatever. But it is better to try to give them a set amount rather than saying 1% or 5%. Whenever you leave money to a charity, the Attorney General has to be notified and get involved. And it's like, man, I didn't do the will. He leaves 1% to these miscellaneous charities. They're only getting about $7 grand a piece out of the pie. But the Attorney General required a formal accounting, which was more than 10 grand. I said he should have just said, listen, I give 10 grand to this charity, 10 grand to that charity, rather than a percentage. And two, we also want to have a clause saying, if one of these beneficiaries is no more, then the bequest typically lapses. When it's charities, if this church ceases to exist, then the bequest lapses. In Monmouth County, the person said, I leave money to X charity, but there was different charities with similar names, and they went to court fighting over who's who. When someone says, I want to leave money to the American Cancer Society, he goes, listen, on their website, they have like the kind of language they want, or a link. Some people have other different charities. Hey, go to the website. They always want the money, but they usually say, we prefer that the language in it said, the Armenian Church of USA at whatever. All right. Okay. So now we're talking. That was specific bequests. There's also, I like to think of something as the reverse specific bequest. I leave nothing to X. Not a dollar, not a reason. Last year, a client shared the story. She said, do I have to treat all my kids equally? He goes, no, you can do whatever you want. Give it to the yellow dogs. I go, what's your concern? He goes, well, one of my sons lives on the West Coast and we don't hear much from him. Okay, did you get a card or a call from him on Mother's Day, your birthday, or Christmas? She goes, no. He goes, why would you leave anything to that bum? Because he's a bum. And the day you pass away, within hours, that bum's going to be, where's my money? I haven't got my, nothing. Not a reason, not a dollar, nothing to them. They know why. It is very difficult to contest a properly drawn will by an attorney. And I did have a meeting call. He goes, I want to contest the will. I wasn't left anything. Okay. The judge is going to ask you, okay, how many times have you seen your dad in the past 2 years? Well, we had a falling out. Okay. The judge is going to ask you, in the past 2 years, how many times have you tried to call your dad or send him a letter or email or a text saying, hey, listen, you said some things, I said some things, I wish I, he goes, why don't we sit down and go have a beer? No. He goes, well, sir, what's your grounds for contesting the will? One man hired us to contest the will, and there was a letter that we found that he sent to his mom. You mean nothing to me. I go, sir, stop wasting your money.
Excuse me.
Certain assets. Oh, your question. Your question was, are there any more of those books? Yes, ma'am. All right.
Who gets this book?
Go around.
All right,
Down around, in front of the camera.
So this subject of actually naming a person who you definitely do not want any assets to go to.
Nothing to that person's name. Not a dollar.
And you had mentioned reason.
Don't put any reason.
Oh, but
No, they know the reason.
But maybe it's good if the lawyer should also be aware in case so they want to contest it.
No, let's see. Here's I'll go. If you put a reason down, they might say, well, that reason's not true. I never did that or that. Nothing to X. Okay? Now, here's something I'll mention on hiring a lawyer. Let's see. The ones that get contested oftentimes are the ones where someone did it themselves and a family member said, here, Mom, Dad, Uncle Joe sign, and it's done in the hospital or assisted living, whatever. And I won't get involved with those because they smell. And something that smells in the beginning never smells better down the road. See, you know, my late mom used to take the moldy bread and put it in the freezer, hoping that maybe it got better, because they were from the Depression. And sometimes I would take stuff, I put it in the freezer, maybe it won't be as bad. He goes, nah, it never gets any better. Now, there was one different person calls me up. He wanted to challenge the will. Why not? Well, I think my sister did shenanigans and brought Mom and you know, so he showed me a copy of the will. And I goes, sir, you got a very difficult time. I go, this will was prepared by you know, Mr. R by Old Man R. Biter and Metuchen. And I said, listen, I can't stand this guy. But he's a good lawyer. And he did it. And there's proper witnesses. And you have a tough time trying to sell Judge Mignola, the probate judge, that he's a screw up. What then the judges do look at is if the will was done, you know, by the person that was in the nursing home, in the assisted living, and the witnesses are other family members, and there's unequal distribution. So that's why at least when you're having an attorney do it, you're getting 3 independent people that if you know, if there was ever a will contest on one of ours, the judge would say, what I'm going to do, you know, basically, how do you know they'll go up? We send them the will ahead of time. Before they schedule an appointment, we ask them 3 questions, and they can't come in until they say, did you read the printed version? Does it contain what you want, and do you have any questions? I read the printed version because I don't want people reading on their cell phones, because those are the ones that don't read it. Yeah, they read the first page because you never. Okay, and it was then when they come in, we ask them those questions. We ask them to show ID. No one's in the room when it's signed, and then they get the originals to take home, because the originals, by the way, are the person's property. Only the original will can be admitted to probate. And back in 2003, there was an opinion by the Supreme Court Committee that the wills are property of the clients, and they should be held by the clients, not by the attorney. So since 2003, the only time I have kept an original will is where it's a family member and they said, Kenny, you're the executor. Sometimes the client will say, listen, I don't have any, aside from my spouse, I don't have any relatives in the United States. Will you be the executor of the will and make sure that the people I picked get the stuff? I goes, only if you put that in an email to us to comply with the Supreme Court thing, because there was another directive saying the attorney could just put their name down as the executor, because that was a fast one back in the 1970s. Let's say, you know, this man would come into the law office in 1979, and the lawyer would do the will saying, oh, my trusted attorney, Mr. Arbiter, is the executor. And the client goes, I didn't know who Arbiter was until that day. So not allowed to do that. All right, so yes, sir, in the back. He's dead. He's young, but he gets the book anyway. Just so I less stuff to. He can give it to a relative that's. Yes, sir. What's your question in the back?
Yeah. So the questions. I have a couple of questions.
You get one.
Okay.
You get one on wills. Okay. It's already 6:36, and they turn the lights out at 7. Got it.
So let's say we have the assets in New Jersey State, and we move out to any any other state and live over there, what happens to the assets?
Okay, the question is, if you move, you have a will done in New Jersey. A will done in New Jersey is valid in every other state in the United States. Okay? So, if you have your will done here, and if someone gets transferred their job, or one day in the winter when it's snowing, they goes, you know what, I've had enough of snow. Let's see, I'm going to a warm place. Let's see. And the will is still valid there. You know, by the way, how about this morning? You know what I did you know what I did on Saturday? I took all the ice scrapers and winter stuff out of my car and put it up in the where we put the winter stuff because it's so hot. I made sure I had the bug spray, the tick spray from running. And this morning I go to take my daughter's dog for a run. He goes, "What's this on? Oh, this must be dew." And I go, "No, this is ice. What's this all about? I'm done with snow." Now, Andrew, there's a difference between valid and best for someone. So if someone's moving to another state, I tell them, okay, number one, your will is valid in any state you move to, but it may not be best for you. New Jersey is a probate easy state. It is a probate easy estate. That's why when people ask me about having fancy revocable trusts and stuff like that, I goes, you don't need to spend that $7,000. Your will typically is fine for what you need. You don't need that thing. Now, if you live in New York, California, Florida, you really should have that because it's like, those are probate complicated states. It was funny. My mother-in-law is 94 years old. She lives in Monroe. She used to call me every other year. I want to come in and get a trust done. I would say, "Were you watching Susie Orman on TV?" She'd smile, "Oh, yes." Well, Susie Orman is right if you live in New York, California, Florida, where probate is very, very complicated. You don't really need that in New Jersey. And by the way, Susie Orman, her company sells trusts. It's like, I recommend this kind of whatever. And by the way, we sell this. So not really something that people need. Okay, now your
Can I ask you
assets.
a quick question?
Yes, ma'am.
Just a quick one. You don't have to do it. But what, like,
That's it.
like I had stepkids, but they're not really my steps anymore since he died. Do they go under my will?
Well, here's the question. Most people say, you know what? It's your call.
No, I didn't know.
If you don't. Now, you want to put in, you want to have a will that says either they get or they don't get. So there's no question at all. Especially if, you know, the kind of the rule of thumb is it someone that I've seen or heard from in the past couple years? If the answer is no, then what, you know, then there's other people that you care about usually more. You know, there's no law that says fair. The law is who you want. And remember, you don't believe anything. You know, some people don't believe in anything to that one grandkid. He doesn't work. All he does is drink and whatever. One lady did a will. She goes, "Listen, I love all four of my kids, but my one son can't help it. He has an alcohol problem. Instead of giving the money outright to him, even though he was an adult, she set up what's called the testamentary trust within the will, where the executor, who was one of the other kids, would pay his rent and pay what to have him supported, but not just give the guy a check for like $190,000, where he just would have said, "Hey, let's have a party." You know, it's kind of like, if someone doesn't have a will that's minor kids. There was a guy in my high school track team. Let's say his mom had passed, his dad didn't have a will because he was in good shape. The father's killed. The guy on my team got $75,000 in 1978 money, and by the time he was 21, spent it all on parties and whatever. Right? Okay. Now yes ma'am.
I have a quick question.
Dan, she gets this way on my, she gets the last one.
You explained that what happens is the law changed in New Jersey and it made it easier. What about if there's just a husband and a wife? Thank you. A husband and a wife and no children?
Well,
How is that?
what you want to do is decide, kind of like, hey, that's why you want to have a will. If there's no will, and the spouse is predeceased, there's this statute that says, okay, third cousins to the second degree, whatever. And some people says, you know what? Or if there's no one close, then it goes to the state of New Jersey. I mentioned no one wants the state of New Jersey to get it. And some people says, I had a client, she says, my spouse passed, my sister's passed, we don't have any kids. She goes, I wanted to go to these 3 friends of mine and this charity. And I don't want them to know about it until after I'm gone. And goes, why should I leave it to some second cousins in California that I've never seen before ever? So that's the idea of having that kind of plan. Now, there are certain assets that you could have the best signed will ever, and it's all nice and stamped, and certain assets don't pass under the will. So, for example, they pass by title. If there's a house and the deed says husband and wife, automatically goes to the survivor. If there's bank accounts payable upon death, joint tenants, CDs that are payable, automatically go to wherever you put them. Sometimes some people say, oh, I put my one daughter or son on these accounts so that they could access my money, the money so that they could pay my bills. And I said, well, you understand that if you pass, they get, that's their money. It goes, yes, but, I'm sure my daughter will do the right thing. It goes, I'm sure your daughter will do the right thing while you're alive, too. I mean, Mother's Day's in 3 weeks, and she's not going to say when she's bringing over, like, flowers. Oh, by the way, when you go, I'm screwing my brother and sister and keeping the money for myself. And in that kind of situation, sometimes it's not your own blood, it's whoever the in-law, their husband's going to say, hey, the lawyer says we can't, my lawyer says that's all our money. Why are we giving it to these guys? Well, because I want to be fair. The husband-in-law says, screw fair, that's our money. We need the money for our trip to Vegas. Other assets passed by contract. Review of IRA, 401k, life insurance. If there's a direct beneficiary, the will does not change that. Our recommendation has been get a printout of a paper printout. If you don't have a printer, say to the company, listen, I want you to mail me a couple pages of this. They say, you can say, listen, if you're not going to mail this to me, no problem. I'm going to move my assets to another company. Okay, I will get it to you. Because it really helps the executor when they can see, when you just have a 2-page printout and it's with the will. Okay, these are assets that we know about that already has a direct beneficiary. Let me talk faster. Some people who work full-time, they're part of companies that have what's called legal plans. So some people have the MetLife legal plan, ARAG legal plan, legalese, that actually pays for the wills. So we participate in some of them. Okay. Now, the last thing I say on the wills, Dan's heard this before, get your stuff done. Don't put it off. Don't be like Carl. Now, Carl was this retired engineer that used to go to every Edison council meeting and put his suit and tie on and, stand up at public section, and he would say, oh, the taxes are too high. Well, Carl, no one knew Carl had a couple $1 million. And Carl, comes to see us, and I say, listen, I would recommend we do this, this, and this. Carl goes, well, I'd like to read more up on this. Carl, you don't need to read anything. I went to law school, I passed the bar, I lecture, I wrote a book on this. I said, when I need a knee surgery, I didn't read about how he was going to do knee surgery. I don't want to know. You know, if the doctor would have said, you can watch this, 2-minute YouTube clip. I don't want to say it. Just wake me up when you've done it right. Well, Carl said, I want to read up. 2 years later, Carl's daughter calls us up. Do we have his will? She can't find it. No, we never did it. He wanted to read. So, don't put off getting your stuff done. Everyone said, yeah, I'll get it done in the next season or whatever. No one would have know they had a vacation and wait till Friday and say, you know what, I'm going to decide today where I'm going to go. By the way, anyone who go, us and other lawyers typically charge consult fees. We don't charge a consult fee if someone attends one of our programs and then fills out our short form within 30 days, and then we talk to them. Okay.
Well,
Yes.
while we're on the subject of how much it costs, could you give us a bit of a range?
Yeah. Okay. Yeah. So most attorneys, for doing a basic will, usually charge between $500 and $700 each on doing the wills. Someone goes, oh, that's a lot of money. It goes, well, it costs a lot more if you don't have it. So I was talking to a couple, and I goes, if you had a water leak in your basement, would you say, I'm going to get this fixed? Or would you say, you know what, I'm just going to let it keep leaking, and then after I die, I let my kids worry about it. No, you get it fixed. So you get your stuff done, you spent the money, and you make it easy. Okay, I've already touched upon this thing called revocable trust. Now, in New Jersey, most people don't need to spend $5,000 to $8,000 setting up these fancy revocable trusts, because New Jersey probate is not that complicated. It's relatively inexpensive. A revocable trust does not protect assets. So many trust salesmen talk about, the trust is private and a will is a public record, but most people don't care that the world knows who they're giving their assets to. I mean, they're not giving it to like terrorist groups or something like that. Now, there's a different kind of trust that some people ask about. So it goes, in case I go into a nursing home, I want to protect my assets. That's a thing. Well, so if the house is owned husband and wife, one of the two has to go into a nursing home. What's called a committed spouse gets to stay there, and that can't be taken and used to pay for a nursing home. Let's see. But kind of more importantly, let's see. One time, daughter calls us up, and I want to come in with mom, and mom wants to protect her assets. Now, this isn't my first day. I could smell the daughter was wanting to protect her inheritance. Not mom would know. So the daughter's like, I go, well, you know what? If you really want to protect mom, you could spend your money and take out long-term care insurance to pay for nursing home. Daughter, of course, like, well, I don't spend my money. And then the daughter says, well, what did I do? I goes, me, I'm not transferring my assets away to my kids or to one of these irrevocable trusts so I'm penniless. Let's say I'm not going to rely upon my son-in-law to ship me to Alabama to the crappiest nursing home there, so there's more money because it's cheaper. I've been working since I was 13 years old. I was delivering newspapers in the rain when I was 13 and collecting money. So if I am that, me personally, if I am that sick that I can't brush my teeth or feet, I want to go into the best nursing home that exists for that month, week, whatever, because it's my money, and I want to get the better care by someone that's paid a decent salary, and not the one that is getting minimum wage that doesn't answer the phone, the ringer. Okay, quick, I got to talk about powers of attorney. What a power of attorney is, it's the document that wills for your assets when you die, the power of attorney is while you're alive. You're giving the power to a family member or someone else, a friend that you trust, where it says, listen, while I'm alive, but if I can't get up and act and pay my bills, you're authorized to act on my behalf. It's either effective right away or only upon disability. We recommend that it be effective right away, so you don't have to go and prove that the family doesn't have to prove to banks, whatever, that someone is disabled. We also recommend that a new power of attorney be signed every 5 years, even if the same people, because a lot of banks, financial places, if it's something that's 9, 12 years old, they might say, well, how do we know this is still good? Also, there was a New Jersey, an update to New Jersey law where some of the banks or financial places were giving people a hard time. They would say, oh, it wasn't done. We need the person to sign our Wells Fargo form or whatever. So the legislature said if it was a bank doing business in New Jersey, they had to, and it had the specific New Jersey language, they had to honor it. But it had to make reference to Section 2 of PL 1991, C95, C46:2B-11, and cheap and free stuff online doesn't have it. Fred the Carpenter, on the day of his signing, goes, Kenny, explain to me I don't understand legal stuff. Explain to me in carpenter language what this means. Okay. Fred, you have a son, and you want your son's going to be your agent, right? He goes, okay. If it's effective right away, your son can steal all your money the day you sign, and then take it and move to Cuba where it's warm in the winter. If it's effective only upon disability, he has to get a note from a doctor before he steals all your money and goes to Cuba where it's warm in the winter. Knowing that, you trust your son. Because I trust my son in my life. Good. Make it effective right away. I only use the word Cuba, by the way, because they don't have an extradition treaty. If it's another country, then the U.S. Marshal and other people can pull them out and say, hey, you're under arrest. Yes, ma'am.
Can you just say in more simple language what a revocable trust is?
A revocable trust is a document. What it's like? It's a paper you sign saying, who's getting your assets and what the powers are. Okay? But the most important thing you got to remember about this revocable trust is you're not owning the assets anymore. You're changing, you're having a new deed to your house that says, the house is not going to be owned by me, it's owned by the revocable trust. I'm taking my money, and instead of me owning it, it's going to be, the new owner is the, Ms. X Revocable Trust. You're taking other assets, that's the new owner. Just signing now, I mentioned in New Jersey when people say, I want to transfer my assets into a trust. I turn around and goes, whoa, why do you think you need a revocable trust? Other than the fact that Susie Orman on TV sells them. And oftentimes it's my friend has one and says I should get one. But your friend does not live in New Jersey, correct? No, they live somewhere else. Or my daughter says I can get one. Does your daughter live in New Jersey? The children that say someone should get something, you should be like what I told this one lady, the daughter. Good, why don't you spend the money? Well, I don't want to spend my money. So, if we're doing a revocable trust, the fee is $8,000. And people don't need it. If someone, Mr. M, one of my neighbors, goes, Kenny, you've been very honest with me, but I still want to take the houses that don't have a mortgage, put it in a revocable trust, and the day after I die, my daughter, who's the trustee, can, sign, have it, the deed into her. Okay, listen, I want to be honest. But most people, as I mentioned, don't need it. I wish everyone, after I'm 100% honest with them, says, no, I want to have the deed. But there are trust salesmen, and they sell stuff that you don't really need. And when the good Sisters of Mercy were beating on me in grammar school because of whatever I did wrong, they were also trying to beat into us to be honest and fair with people and not just do what was in our best money interest. Okay, real fast because I'm over my time. Living Wills Advanced Directive. That's the document where you're saying, hey, listen, someone's in a coma, irreversible condition. They're never going to have their eyes open again. They're just lying there. You're giving instructions to hospitals and doctors saying, listen, I don't want to be on feeding tubes, life support, etc. Let's see. Me and Dan run every single day, doing triathlons, and today was the Boston Marathon, which I qualified for and ran years ago. And if I don't want to be a burden unconscious and be a burden on my family. And the living will isn't really a document for you. It is a document for your loved ones where you're saying, listen, this is what I've already decided. Because otherwise, if you don't have it, the doctors have to go to the family and say, okay, we need you to decide. And one time, a little lady, she didn't have the living will. She had a power of attorney, a will. I was the power of attorney. And the doctor goes, okay, should we remove life support? I goes, geez, I feel bad. He's asking me, like, should we turn the light switch on? I goes, geez, I feel bad. You know what the right decision is for someone who's 92 years old that's not going to open up their eyes again. But I wish the lady would have had it. This is why I encourage people to have it. And with that, I'd say my name is Ken Vercammon. People have these new things called pens. You can write down our office phone number, 732-572-0500. Typically what we do, someone calls the office and say, listen, I want to come in for an appointment. Sure. First, we're going to email you the short form that asks those 7 questions before someone comes in. Let's say, and I've kind of learned that once I get those 7 questions, I've kind of saved them the trip. Let's see, Mrs. Shaw goes, okay, when can I have an appointment to come in? Okay, Mrs. Shaw, you're married, right? Yes. Are you disowning your wife for giving everything to her? Everything to her. Okay, Mr. Shaw, I see you have 2 kids. Are you disowning either your kids or treating them unequal? Equal. I already know. I know what you need. You don't need to take a day off of work. Right? All right. Dan Fabrizio. Tell everyone what they need to know.